Good afternoon, everyone. This is Jordan Schwartz and Dan Deacon from Confidentiality. We are very pleased today to bring you this presentation. We called it Best Practices for Protecting Your Company's Primary Assets, your company's workforce, trade secrets, and customer relationships. As some of you might know on this call, trade secret cases are some of the most intense and demanding cases because it's such an important part of what you all do. And if you are threatened with an action, or you have an employee leaving and then you have to threaten an action, these are super quick cases where you need to kind of get your act together right away and figure out what you need to do to protect your company. So that's why Dan and I figured we would just give this presentation today just so you're thinking about these things and have some sort of game plan if the unfortunate need arises in the future that you'll have to address some type of trade secret or non-compete type issue. For those of you who don't know me, my name is Jordan Schwartz. I have been a partner at Confidentiality since we started almost 5 years ago. I do a lot of non-compete work. I've done it throughout my entire career and been on both sides. For non-compete work, it's interesting because we defend the company either who's getting sued with a non-compete type complaint, or we defend a company who has someone leave and might have to prosecute a non-compete type claim. In addition to that, I do a lot of ADA work. I do discrimination work, both defending lawsuits and counseling employers on compliance with all sorts of the federal and state local laws. Before I turn it over to Dan, let me just mention that you can see in the chat on the bottom left that everyone's line has been muted, but if you have any questions, please type it into the search box. And Dan and I are hoping to only talk for about 45 minutes so we have some time to get to questions. Typically, I love to hear myself talk, but hopefully I'll do a good job of limiting the presentation so you have time for questions. Also, we are recording today's webinar, and we'll circulate a link to the recording and our slides within the next few days. With that being said, I'm going to let Dan introduce himself, and then he's going to start with the first portion of the presentation, and then I'll pick up thereafter.
Thanks, Jordan. This is Dan Deacon speaking. I'm an associate at Confidentiality. I've been here for about 4 years now, a little over 4 years actually, and I work in both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. So I represent employers in inspections and investigations by federal and state OSHA, and on the labor and employment side, I'm handling everything under the sun, including wage and hours disputes, claims of discrimination, and I also assist on these non-compete issues as they arise. Additionally, I help review and revise employee handbooks and policies, some of which we're going to be talking about today, and other workplace safety policies and procedures. So moving on to the agenda here really quick, this gives you an overview of what we're going to be discussing today. First, we're going to be talking about trade secrets. What is a trade secret and how do you protect it? Next, we'll go into non-compete agreements during hiring and termination, how to draft those agreements, and some legal considerations. Then we're going to follow that up with some legal updates from 2018 that you should be aware of. And then we're going to conclude with some key provisions that you'd like to see in some of your agreements, such as choice of law provisions and forum selection clauses. So to start, as I mentioned, we're going to talk about first protecting trade secrets. And it's helpful to start with an overview of what is a trade secret. So most employers are going to take a different view or an approach of what is a trade secret, and some employers are going to consider all of their information to be a trade secret, but this really isn't going to hold up. So the framework to evaluate whether information is a trade secret is whether it is confidential and has some economic value. The information must derive its value from not being generally known to the public or other persons who can obtain economic value from its disclosure or use. So the key here is secrecy. That's the key consideration in the definition of what is a trade secret. So it doesn't have to be absolute secrecy, but the information should confer some competitive advantage to the person who would possess it if it is in their hands. So another consideration is whether the employer takes efforts to maintain its secrecy and what those efforts really are. So you need to have some type of steps in place to make sure that information is held private and not disseminated to others, be that the general public or even employees within your company that don't need that information. They shouldn't be privy to that confidential information. So this is an area that's frequently litigated, and it pops up often. So finally, there's the last bullet here. There's the Uniform Trade Secrets Act, and about 47 states have adopted this, and there's now some more uniformity among states in defining what a trade secret is and how to seek enforcement. So there is a remedy for employers when there is misuse of that information, and that can be your starting point in doing any potential research that you'd like on what is a trade secret, how it'll be interpreted, and how you can enforce any potential issues related to that information. So now continuing further on in this inquiry of what is a trade secret, it's really a highly fact-specific inquiry, and there's no set standard that I can tell you about what exactly is a trade secret. It's dependent on a number of different variables, and you'll be looking primarily at the nature of the confidential information and the role it plays in the company. And you see a number of the factors here on that screen. So if it's essential to the lifeblood of the company, if that information is critical to the business operations and release of that information into the wrong hands would cause serious damage, that's a serious consideration that courts are going to be looking at. Also, is the information known outside the business? If it's known to competitors or the general public, then it's likely not going to be considered a trade secret. If it's information, however, about pricing or key contacts for customers, some of that detailed information that you wouldn't want competitors to have, this would be something different and likely considered a trade secret. Courts also take into consideration the safeguards that a company has in place to protect this information. So when we're talking about safeguards, do you have policies regarding confidential information in your handbook? Is there training on what confidential information is and how to handle it, or what a trade secret is? Are there confidentiality agreements between you and your employees? Those are some other factors that courts will be looking at. Again, going back to the economic value of the information, this is critical. Courts are going to be looking at how valuable and how critical that information is to the lifeblood of the company. The more valuable that information is to your business processes, the better, of course, and that would be considered a trade secret. Courts, finally, will also take into consideration the effort or money expended in developing this information, whether it's the linchpin of the economic viability of the company. That's certainly important. And finally, courts will also look at how easy or difficult it would be for the public to access it or for competitors to simply develop it. So these are just a couple of the factors that courts typically evaluate in determining whether information is considered a trade secret, but keep in mind that this varies greatly depending on state law and the court interpretations within your respective jurisdiction. So this slide, we're we're just listing a couple typical examples of trade secrets, and some things that you should keep an eye on in the running of your business. So you really want to, as an employer, interpret confidential information broadly, whether that's going to be considered a trade secret by a court if it ever got to potential litigation. That's a different story. But for purposes of running your business, you want to interpret what you consider confidential information somewhat on the broader scale. With that caveat, keep in mind that if a dispute occurs and you end up in court, there could be information that you consider confidential that might not rise to the level of confidential trade secrets. So going back to the list here, we just have a handful, a little more than a handful here that are typical examples of trade secrets. First, beginning with customer lists. This is a heavy litigated area, and not all customer lists will be considered confidential. If the customer's identity is common knowledge, that may weigh against finding it as a trade secret. It may depend on the size of your industry. Within the list, however, there could be trade secret information within that list that you maintain, such as key contacts, pricing, things that if that got into the hands of the general public or a competitor, that could be damaging to your company. So generally remember that we're looking at and evaluating the economic value of that information and how it could ultimately negatively impact and affect your business from a competitive and financial standpoint. So some of the other things that we have on there are formulas, manufacturing processes, marketing plans, pricing information, as I mentioned before, research studies specific to your business or your strategic business plans, and then testing data and training manuals, for example, training manuals on products that you developed and that you offer as a service that could harm you if that information gets out into the hands of a competitor, for example. Now moving on to how do you protect trade secrets. It's not just enough to designate information as a trade secret and call it a day, right? You need and want some type of policies in place to direct employees how to handle that information. So we recommend having confidentiality agreements outlining the limits of how to handle information and what is considered confidential information at your business. You want to describe what information is confidential in detail. So don't just take a boilerplate agreement and apply it to your business. Tailor that language specifically to what you're actually using and applying at your business, and make sure that language is clear and easy for employees to understand. You also want to outline the restrictions on how it is used in the employment relationship and prohibit employees from sharing that information. Also on the screen here, you want to prohibit employees from soliciting customers and former colleagues, but keep in mind this may vary by state law. For example, California is pretty strict on the limits of non-solicitation agreements and whether they're enforceable at all. So it's important to not only have these confidential agreements, but you also want to have confidentiality policies in your handbooks, your employee handbooks. Incorporate those policies into your processes as well. So when we're talking about these processes, we're talking about training, but also do you have password protected access to confidential information? You want to have a way to confirm exactly what was done in the event that that confidential information is taken and shared with others. That will help you build your case if you ever end up in a trade secret prosecution, and also anti-deletion programs. If you don't need the confidential information anymore, delete it. Finally, do you label documents confidential in your hard copies or electronic formats? Make sure to label them specifically as confidential, or trade secrets, and employees will have a clear understanding of the import of that document and what to do and not to do with it. So some other internal steps to protect trade secrets is to limit access to confidential information, and we touched on that on the last screen. But not everyone in your company needs access to a lot of information within the company. So it's best to just keep it on a need-to-know basis and only provide that information to designated individuals, those that need to know the information. So don't be disseminating confidential information to everyone in the company. Finally, you're also going to want to dispose of documents completely if they're not needed. We talked about that a little bit on the last screen as well, and also the company policies and training on those policies, making sure employees understand how to handle information and how to keep that within the company. Also, the one important bullet on the slide here is taking periodic inventory of your confidential information. How are you actually preserving it, and consider whether there's actual issues in maintaining its confidentiality. So again, reviewing your internal processes to make sure that you are doing everything that you can to keep that information close. So finally, we're getting into the confidentiality and non-disclosure agreements and what those should look like. And Jordan's going to talk in detail about non-compete agreements. That's something a little different. But when we're talking about confidentiality and non-disclosure agreements, you want to draft those carefully depending on where you do business. It might be different depending on the state where the employee is located. Really what you're looking at here is whether the agreement is reasonable. That's going to be the key consideration that courts are looking at, and that's all dependent on applicable state law. So going back to California, for example, they have a number of different restrictions on non-disclosure and confidentiality agreements, and you're really going to need to tailor any employment agreement that you have with an employee to conform to those specific restrictions. So it may be different for an employee in California than it is for an employee in New York. And that's something to really keep in mind if you're a nationwide employer. Having one boilerplate non-disclosure agreement, it simply might not work, and it likely won't work if you have employees in all 50 states, for example. Generally, however, what you see on the screen here are the factors that courts are typically looking at, and that includes the interest of the disclosing party in keeping information secret, the period of time the information must be kept secret. So where it gets a little dicey is at the end of employment and beyond. How large is your interest in keeping that information private? The burden, third, the burden of compliance on the receiving party. Here we're asking, is it imposing an undue burden on the employee in performing a job? Perhaps we're going to see somewhat of an example of this later of a court case where a non-solicitation agreement was deemed to be the equivalent of a non-compete, basically, and that was unreasonable and too burdensome on the employee. And then the last one here is the interest of the public. That's the final factor that courts typically look at in determining whether or not an NDA is reasonable. And with that, I'm going to turn it over to Jordan, and he's going to talk about non-compete agreements and best practices for them.
Thank you very much, Dan. Okay, so we are going to switch topics just slightly. Non-compete agreements are related in some ways to trade secrets, but there's a lot different and more of an analysis that goes on here. One important thing I wanted to start with is if you don't have non-compete agreements, and I have clients who call me all the time and are considering whether or not to institute them. Definitely a best practice is to require employees to enter into a non-compete agreement before beginning work. The reason for that is when it's executed as part of an original, employment agreement, or just when it's executed once you start work, the offer of employment in and of itself is generally considered adequate consideration for the covenant. And as you can see, the third bullet point says, in order to be considered valid, a non-compete agreement must be supported by consideration at the time it is signed. It also needs to protect the legitimate business interest of the employer and be reasonable in scope, geography, and time. And we'll get to both of those in a minute. But in terms of consideration, right away you give someone a job offer and you give them money for the job. That's consideration. If you have an employee who's been working for a few years, and then you decide they should enter into a non-compete agreement both for the rest of their employment and then for some specified term thereafter, the question of whether there is adequate consideration just because there's continued employment, that becomes much more complicated. There are some states that say, yes, continued employment is adequate consideration, but there are other states that say continued employment, regardless of the length of that employment, does not constitute adequate consideration for a non-compete agreement. So what you'll need to do in that case is give the employee a bonus, some sort of additional cash consideration, or potentially not even cash, but some sort of change of title and change of job duties. But that often is just a step that some employers don't want to take. It's just easier, and it reduces your potential liability, and it's just stronger from your side to be able to argue that the individual has always been subject to a non-compete agreement during the entire time he or she has been employed. Most people know, who are in this area of law at least know that California does not in any way permit non-compete agreements. The same thing more recently, Oklahoma and North Dakota have had cases that now specifically state that they don't permit non-compete agreements, and that's in the employer-employee relationship. They might be able to be enforceable in the sale of the goodwill of a business, where the seller can agree not to compete with the buyer. But for the most part, we're not talking about that here. So if any California employers are on the phone here, I'm sure you know that California does not allow non-competes. They do in some circumstances, as Dan mentioned, as he'll talk about later. They do typically allow non-solicitation agreements where you can't leave and solicit both employees of the company you used to work at and or clients of that company, but there's even some case law that calls that into question depending on the facts. But those typically, at least, they're not per se unlawful under the California statute, as is just a blanket, you can't go work for a competitor. As for almost all other states, typically the case law comes out that the states disfavor non-compete agreements. But as long as they meet certain requirements, they are not prohibited and are in fact generally enforced. They cannot be a restraint on trade that interferes with competition and or impairs the availability of services and the ability of workers to follow personal interests. And again, in the next few slides, I'll talk more about that. Because of that, courts will scrutinize non-compete agreements closely. So what we want to do, advising you as an employer, is to not even undergo that scrutinization and draft reasonable non-compete agreements that are narrowly tailored. And the main question there is narrowly tailored to protect your legitimate business interests. It all comes down to whether or not you are requiring these employees to sign a non-compete agreement just as a matter of course or as a matter of vindictive nature. Neither of those suffice. But if you're doing it to protect your investment as a company and protect the things you have spent time, effort, and money developing, including employees, then a legitimate interest may well be found. So the first bullet point here is just very important. Regardless of how well a non-compete agreement is written, virtually no court will enforce it unless the employer can identify some sort of legitimate business interest that the restrictive covenant is seeking to protect. I'm going to try to define legitimate business interest, but this is really developed through case law, and case law has differed and expanded over the years upon the meaning of legitimate business interest. And this is a subject that just varies a lot by jurisdiction, so there's really no one-size-fits-all answer. Typically, a court will apply a totality of the circumstances. They will look at everything going on in the situation to determine whether the employer has sufficiently identified a protected business interest. Often courts are somewhat reticent to define the term legitimate business interest because it's such a case-specific inquiry. But they often are clear, however, on what is not a legitimate business interest. And it is not a legitimate business interest to simply protect the employer from general competition. That just does not suffice. Employers do not have a case. They do not have a cognizable legal interest to prevent employees from competing, even if the employees use general knowledge, skill, or wherewithal that they've acquired through training or experience during their previous employment. There's a doctrine called the inevitable disclosure doctrine that an employee can't, forget his knowledge. He'll inevitably be able to use what he's learned, but you cannot use and divulge, various trade secrets, as Dan mentioned earlier, and that dovetails into what is a legitimate business interest. Over the years, courts have identified the following factors as potential legitimate business interests, and the first one is trade secrets. That's the big one. If you're at Coke and you have the secret formula to Coca-Cola, that's a trade secret, and you can legitimately protect yourself and not let the maker of that formula go across the street to Pepsi and use his knowledge to work at Pepsi, at least for some sort of time period. Other potential legitimate business interests include intellectual property. A big one is customer lists, and Dan mentioned that, has there been secrecy? Does everyone know your customers, or do only you know your customers? And goodwill with customers. Knowledge of business practices is certainly a legitimate business interest. Your profit margins, your methods of doing business, what your costs are, and other information that is confidential, proprietary, and basically increases in value from not being known by a competitor. And even the training and education that your company does certainly can be a legitimate business interest. As I mentioned earlier, in addition to being supported by consideration, a non-compete agreement must be reasonable in scope, geography, and time. The reason for this is the court is ultimately needs to answer the question of whether the non-compete agreement is overbroad. You know, they're not going to let an employee just not have a means to, you know, earn income. So based on that, the inquiry is, as I mentioned earlier, based on the totality of circumstances, and it must be limited, a non-compete agreement must be limited with respect to time and scope so that it is not greater or broader than necessary to defend the legitimate business interest of the employer. And there isn't a one-size-fits-all answer to this, but usually a time period of 1 year or possibly 2 years is presumptively reasonable, especially if an employee is receiving severance over some of that time. But if you're going up to 3, 4, 5 years not to compete, unless an employee receives an extremely generous severance package, that just seems like it's likely going to be too much. The geography, you know, the non-compete agreements started years ago when they didn't want a business to, you know, someone to quit and then open up shop across the street and take customers, the employer's business away from him. It's a little bit more complicated now since so much business is conducted nationally or even internationally. So it's possible you can have a reasonable non-compete agreement that is nationwide or even worldwide, but you do want to try to limit it as much as possible. And as for scope, typically you want to prevent an employee from working for a competitor in the same capacity that he or she currently works. Now, this is called the janitor rule, and Dan will discuss a case that mentions this. You know, if someone is a you know, engineer in one organization, you can't have a non-compete that prevents them from going to a competing organization in any capacity. You know, the case law says, what if he wanted to be a janitor there? He wouldn't be using the trade secrets or the wherewithal that he learned in his previous employment at the new employment. So the scope means it should be someone cannot be employed in the same or similar capacity. There are some professions that typically aren't subject to non-compete laws, most notably lawyers, and I like to say that's just because lawyers write the laws and they don't want to have to deal with non-compete, so they you know, exempted themselves from non-compete laws. The rationale is that clients should have their free choice of counsel, and they shouldn't be prevented from seeking counsel because a previous law firm prevented an employee from competing. Other industries, sometimes physicians, nurses, psychologists, things of that nature cannot be subject to non-competes, but that varies by states. There still are actually plenty of states that permit non-competes between lawyers. The other one that's interesting is broadcasters, and quite frankly, I do not know the reason why, but for some reason the case law has developed that broadcasters typically cannot be subject to non-compete agreements. Basically, for all of these, though, it's just a justification of the free flow of information and ideas that you might think there's other job titles that should be exempt, but for whatever reason, these are really the only ones that have been so far. Moving on slightly to, you know, we've been talking about entering into non-competes, but now I want to talk just for a minute or two here about hiring employees with potential restrictive covenants. And the key is to take reasonable steps to protect your business from interfering with your competitors' restrictive covenants. Because if you hire an employee who has a non-compete, while that employee might get sued by the previous employer, you also will get sued, and you're the one that the previous employer is going to care about. So initially, during the interview process, when considering a new hire, you should always ask whether or not that individual is subject to any employment agreement including any restrictive covenants, so you know what he or she can or cannot do. If there are such employment agreements that contain non-competes, make sure to obtain copies of them. Don't just take his or her word for it, so you can review with your counsel what you can or cannot do. Inform the applicant that your company insists on full compliance with employment agreements, and you take that seriously. Because as a company, you do not want the applicant you don't want any indication that you allowed or encouraged the applicant to disclose or use a competitor's confidential or proprietary data. When you hire the individual in your offer letter, you want to confirm that the company expects this employee to comply with the former employer's restrictive covenants. After you hire the employee, you want to review any restrictive covenants with the employee to ensure that everyone is on the same page and knows how to comply. If the employee has a list of customers he is not allowed to work with, that doesn't do any good if you don't know about that list, so you don't know not to assign him to those customer accounts. You really all just need to work together and be on the same page. And you need to create some sort of boundary so that the employee is not performing work on accounts that he should not be performing work for. On the other hand, if you have an employee who's leaving for a competitor, you need to take reasonable steps to secure your company's confidential information. At the exit interview with him, you need to make sure to review his employment agreement and remind him of his obligations to maintain confidentiality and his duty not to disclose trade secrets or to solicit any clients or employees. So you want to make sure to conduct a comprehensive exit interview. Make sure to collect all property that you've issued the employee. Definitely remove any access to the computer network, the email, the servers, secure hard drives from his laptops, conduct inventory of his electronic copies and files, and you may even want to contact the new employer and notify them of the employee's obligations under his or her restrictive covenants and associated agreements. Finally, you want to make sure you secure your marketplace position. You want to fight for your customers and businesses because they may be fair game. You want to identify publicly to your employees at least what customers you want to focus on. You want to assess which ones are the most vulnerable and make in-person contact as soon as possible, because even if this departing employee isn't making contact, perhaps someone else at his new company may be making contact. And you want to send correspondence to your customers announcing why they do business with you. You don't want to defame a competitor. You don't want to say why they shouldn't do business with your ex-employee. You don't want to say anything bad about how terrible of a employee that was. It actually makes you look bad because you had been employing him for a while. You just want to talk about the positives of your business and why these companies, your clients should continue to stay with you. You want to communicate with your own employees, as I mentioned earlier. Tell your remaining employees about what communications are fair. You don't need to discuss the circumstances of the employee's departure. You don't want employees, to falsely accuse an ex-employee to customer or business partners. Again, that doesn't do anyone any good and could set you up for a defamation lawsuit. You do want to communicate with your current employees about any unusual activity by the ex-employee pre-departure. Did you try to solicit them? Did they give him any information? That is important stuff that you really need to know. And then just wrapping up here with my last few slides before I turn it over to Dan, your obligations as a company regarding confidential information, keep in mind, employees, this is what I mentioned earlier about the inevitable disclosure doctrine. Employees are allowed to use general knowledge, skills, and experience they acquired during their employment, even if it's to compete with a former employer. But these employees cannot use confidential information, proprietary information, or trade secrets that they acquired during their employment with you for their own advantage going forward. That is something really important. And just to kind of set out here in detail, I've listed out the 4 things an employee who plans to compete with his former employer cannot do. And that is, he cannot appropriate the company's trade secrets, he cannot solicit the employer's customers while still working for the employer, he cannot solicit the departure of other employees or business opportunities while still working for his employer, or he cannot carry away confidential information such as customer lists that typically are found to be confidential. My last point here is about if there is any potential theft of confidential information. Unfortunately, you really need to play detective. You can certainly hire a firm to help you do this, but you need to follow certain key important steps, which is securing backup tapes and drives of the emails and network servers, developing with a consultant, most likely, internal forensic protocol for searching backup tapes and drives. One thing, you don't want to be telling your entire company that there was a potential theft of trade secrets. You want to treat theft allegations as confidential, only with your IT department or whoever needs to know it to be, looking into what this theft actually is. And you want to avoid invasion of privacy. This is kind of a fine line. You're looking at what potentially was stolen, but you also don't want an employee or ex-employee considering bringing a lawsuit against you because you are invading his privacy and looking at private information that has nothing to do with his actual employment. And finally, my last text here is the internal investigation should certainly, at the very least, include a survey of email, office personal computer, voicemail, company-issued smartphone, cell phone records, dial-in and dial-out records, card access for entering the building, and video surveillance cameras. And with that in mind, I'm going to turn it back over to Dan to finish up the presentation.
Great. So we just have a few more slides here on the non-compete legal updates, and then a couple slides on forum selection clauses and choice of law provisions. So in 2018, there were a number of updates related to non-competes, and we're going to first start with Massachusetts. So Massachusetts passed a new law in October 2018 that places quite a few limits on post-employment restrictive covenants. So the 3 bullets on the screen here are the key provisions. It now requires that employers pay workers half their salary or some other negotiated compensation during the period they're barred from working for competitors. This is commonly referred to as garden leave, which actually may deter some Massachusetts employers from using non-competes altogether. 2, it prohibits or blocks employees from signing low-wage workers, university students, and minors to non-competes. So there we're talking about typically non-exempt employees under the FLSA. And 3, it also blocks employers from enforcing agreements against workers laid off or fired without cause. So moving on to a case update out of Illinois. This was a pretty interesting case. This is a federal court endorsing what's commonly referred to as the janitor rule, and Jordan had touched on this a little bit during his part of the presentation, but this is essentially a rule of thumb in restrictive covenant law that if a non-compete agreement restricts the scope of a former employee's future employment indiscriminately, untethered to any legitimate business interests, that restriction will be considered overbroad. So in this case, Medix, the plaintiff in the case, alleged that an ex-executive joined a direct competitor in violation of a non-compete agreement, barring him from working for nearby companies engaged directly or indirectly in the business of Medix. So the court ultimately dismissed the lawsuit seeking to enforce the non-compete against the ex-executive, and it ruled that the agreement was overbroad and unenforceable. The idea here was that it was so restrictive it would have barred him from working as a janitor at another company. So the judge called that example that that was used in that case a little far-fetched, but not an inaccurate statement of its prohibitions. So the agreement would have essentially prohibited the employee from taking any number of other plausible roles at another industry player or competitor, no matter how far removed from actual competition he was. So this is, a prime example of an employer that was overreaching in their non-compete in that drafting process. And the lesson to be learned here is that it's important to take care of checking the boxes during that drafting process and doing your research on what is permitted and not permitted under state law. So the final update we have is out of California. A California court ruled in this case that you see on the screen here, AMN Healthcare versus Aya Healthcare, that employers don't have an absolute green light to make workers sign non-solicitation agreements. So the workers in this case were recruiters who placed temporary nurses into different positions. The non-solicitation agreement here would have prohibited them from basically doing their jobs altogether. It effectively made that non-solicitation agreement a non-compete, which, as we've mentioned, is prohibited under California law. So this case was limited to the facts, but a lot of talk is out there about the implications of this case going forward and whether courts will interpret it to more or less bar non-solicitation agreements altogether. That's yet to be seen, but we'll be keeping an eye on that going forward. So now we're going to get into the last part of the presentation, and this is related to choice of law and forum selection provisions. So just to begin, what is the choice of law provision? So this is a provision or clause where parties agree to a jurisdiction's law, and that jurisdiction's law will govern any dispute that arises under an agreement. So the objective here is to make sure that a particular body of law is applied to any scenario that you may find yourself in arising out of an employment agreement. There's, of course, a few different laws in different states, and how these are interpreted varies. So this is where, again, research comes into play, and you're going to want to see what may be more beneficial to your company as permitted under those state laws. So choosing a law and a forum really does not provide any comfort to you as an employer if the court is not going to honor that choice. So in addition to substantive law that's applied, courts are going to take different views about what state law is going to be applied in evaluating those agreements. So courts have adopted a number of different approaches in analyzing these issues, but the most prevalent one is from the second restatement of conflict laws, which is most commonly referred to as the most significant contacts approach. So that's a two-pronged inquiry, which basically says as long as there's a substantial relationship between the parties and the law selected, and so long as the law is not contrary to the public policy of the reviewing state, that choice of law is typically going to be upheld. On the other hand, you have some other state laws that are a little more restrictive. California, for example, Section 925 of the Labor Code prohibits the use of contract provisions that apply another state's law or require adjudication of those disputes in another state as a condition of employment. So again, there's two different trains of thought there, and depending on where that employee is located, it may vary. So moving on to some more the meat and bones of these choice and conflicts of law clauses, the difficult question typically arises when assessing whether the chosen state's law actually conflicts with a fundamental policy of the state where the case is brought, and whether that forum state has a greater interest in the matter. And again, approaches are going to differ and vary according to the states, the state laws. So courts such as Virginia, they're generally going to be enforcing a non-compete agreement even if it's unenforceable in its own state, under its own state law. However, other courts won't. They simply won't. It's a violation of their public policy. They're not going to enforce it. So that's why it's also important to include a forum selection clause in your non-compete agreements that outlines where disputes will be resolved. So here we just have a list of a couple of the common pitfalls that you as employers should keep an eye on in drafting these choice of law and conflict of law provisions, or forum selection clauses, I should say. First, as you see on the screen here, choice of law does not equal forum selection. If you have a choice of law provision but no forum selection clause, and the forum in which you're being sued doesn't honor that, you're going to be in some deep trouble potentially, and the original intent of your employment agreement just may be out the window. Additionally, selecting a state that doesn't bear a reasonable relationship to the agreement may render that provision unenforceable. So here, if the choice of law provision is just out of left field, for example, if your business is incorporated in Delaware and you operate in New York and Pennsylvania, it's probably not going to be enforceable if you're choosing Virginia law or South Carolina law for some reason. That's going to be problematic and it's going to be struck down. So there has to be some sort of nexus, and you need to do the research on this and see whether there's a policy in the home forum state that would infringe using the state of the selected law that you're choosing. 3, you want to narrowly draft. A narrowly drafted provision can result in application only to the construction and interpretation of the contract and not to extra contractual claims. So here's where you want to use broader language. For example, New York law provides for independent remedy in tort for parties with a breach of contract claim, and Texas law allows for both a breach of contract claim and a tort claim for intentional or negligent misrepresentation in a contract. So make sure that your choice of law provision applies to any and all claims arising out of that non-compete agreement, including a host of different potential claims that you may find yourself in: tort, breach of contract, fraud, negligent or intentional misrepresentation. The list can go on. So moving on to the last slide here, we're going to talk quickly about forum selection clauses. A forum selection clause is a provision where the parties agree that any litigation arising under the contract will be initiated in a certain forum. So you could be employed as an employee. An employee can be employed in New York, and they may have to bring a claim in Florida. The key consideration here, again, I mentioned this on the last slide, is there a nexus? For example, if that business is headquarters and located in Florida, that would likely be reasonable. If it's headquartered in Florida and they have operations in multiple different states, a forum selection clause requiring that any claims be brought in a Florida court, that is reasonable. But if you're just picking a random state where no business is done and there's no presence in that state, again, that's going to be problematic. So you want to make it clear where the location to sue under the agreement is for any claims arising out of that agreement. Also, you can't write into an agreement consent to federal jurisdiction, or you can't create federal jurisdiction. That's something that has to exist under federal law to get into federal court. So keep that in mind. One other point here is that there are state restrictions on this area as well. So again, going back to the variations of state law, this is very important in all the topics that we've discussed today, is make sure you're doing your research under state law. So if we look at California, for example, California prohibits any contract entered into, modified, or extended after January 1st, 2017 from requiring an employee who resides and works there to litigate or arbitrate any claims outside of California. So if you're thinking of putting a forum selection clause in for California employees that they have to litigate any matters arising out of that agreement in Nevada, that's going to be problematic. Again, we're not going to be creating these agreements using boilerplate language. We can't emphasize that enough. It's got to be unique and specific to the applicable interpretation in state law that you are operating in, where these employees are operating. So again, do your research. And with that being said, we'll open it up to any questions that anyone has, and please feel free to put them in the chat box here or reach out to Jordan or myself after the presentation. And feel free to check out our blogs on the Employer Defense Report and the OSHA Defense Report. And finally, a copy of the slides and a link to the webinar recording are going to be sent out within the next day or so, so keep an eye out for that.
And with that being said, it was a pleasure speaking with you all today, and please don't hesitate to reach out to Dan or me if you have any questions. And we will talk to you next month at our next webinar. Thank you.